The National Association for Gun Rights has been absolutely slaying it lately. It seems like every other day they are in the news making headlines, which is a fantastic thing. And the big story that everybody seems to be following is the Rarebreed Triggers situation. If you guys haven't been following this, then 2 weeks ago, we got a ruling out of Reed O'Connor's office. I covered that, and you can find my video for what he said. But basically, they kicked the ATF in the teeth. And I say it that way because if you read the documents from the ATF asking to stay the decision and the reasonings for it, they seem kind of punch drunk. They seem as though they got the bell rung pretty bad, and they really don't know what to do with this one, which is always a good thing to see. Well, the way this is going down is the ATF has asked for a stay on the decision. Don't think they're going to get it. But also, in response to that motion, NAGR tore them a new one, and that's what we're going to be covering today, because this is actually a very good read for only about 20 or so pages. Today's video is brought to you by Medical Gear Outfitters. They are my go-to stop for anything medical related. It doesn't matter whether you need bumps and bruises kit or whether you need real equipment like chest seals or a cat tourniquet or something like that. They have got a bunch of medical kits over there. Again, they are my go-to shop, and they are great people. I've known Dietrich and the crew over there for going on like 10 years now. So they are definitely a place that you should check out if you're looking to augment your medical equipment needs. And they have a discount code for all of you who are VSO subscribers. You can find that information over on the affiliates page. And special thanks to Medical Gear Outfitters for making today's video possible. So to properly set the stage, I'm going to very quickly paraphrase what the ATF begged Reed O'Connor's office for in their motion to stay. They basically said two things. One, we don't think that we can do this because this is really hard. This sounds like work. And then two, everyone sees the machine guns. Everyone sees the machine guns. Everyone sees the machine guns. Even though they went through a thorough analysis of exactly why the FRT is not a machine gun, specifically implicating the most recent ruling from the Supreme Court under the Cargill decision. Let's go to what NAGR said in the response. Line 1. Defendants continued to deny the fundamental fact of this case. Forced reset triggers do not meet the statutory definition and are not machine guns. Because defendants refuse to accept this basic fact, they continue to trot out the same tired and failed arguments. Indeed, defendants' motions are nothing more than a rehash of the same arguments they have already made 6 times. Defendants are still unlikely to succeed on the merits of their position. Rather, Cargill only underscores that this court applied the appropriate legal standard in holding FRTs are not machine guns. Defendants' motion must fail. They then go into several pages of how FRTs are not machine guns, but I think the best line here is Cargill is clear. It is the physical movement of the trigger that matters, not the movement of the trigger finger or pull of the trigger. The phrase function of the trigger refers to the mode of action by which the trigger activates the firing mechanism. They then go on to talk about the individual complaints of the ATF and how what they are being told to do by the court. It's hard. Defendants can easily comply with all of the prospective injunctive provisions. Simply stop attempting to enforce their illegal classification of FRTs, including through sending false warning notices. Indeed, this appears to be the outcome the court anticipated when they vacated the defendants' classifications. What defendants have difficulty doing is finding ways to evade this court's order by narrowing its scope to the smallest group of people possible. This is a consequence of the defendant's own choices, not the court's order. Defendants' concerns with returning FRTs to plaintiffs and their members is a problem of defendants' own making. The court determined FRTs are not illegal under the statute. Defendants do not have and have never had a valid basis to confiscate or seize any FRT from any American. Under the logic of the court's opinion, all defendants' seizures were illegal, and defendants should return all of them. Plaintiffs were deprived of their property illegally, and their property must be returned if they are to be made whole. The problem is not that the defendants can't comply with the court's order, it is that they do not want to. To the extent defendants are having issues complying with this mandate, it is only because they are seeking to give the narrowest possible effect. Defendants claim that the ATF does not know the identities of the organizational plaintiffs' claim members, let alone which of those members is entitled to return. While defendants are only required to return FRTs to certain individuals, there is nothing preventing them from being over-inclusive. Thus, the problem is not that defendants can't comply with the court's mandate, it is that they are claiming trouble doing the bare minimum and only the bare minimum. To paraphrase this whole section, you boasted about seizing 11,884 of them in a short period of time. You've already had to publish who you stole them from. This should be really easy because all you need to do is drop them in the mail. The NAGR goes on for 25 pages of absolutely packing in the ATF. And you should go read this document because this is the type of language that I like to see in legal documents. Sometimes these things get really dry and boring. This one had a little bit of fire in it, and that's good to say. I think possibly the best line to kind of leave you from the document was something along the lines of, yeah, this is hard, so we're going to ask that we don't have to do it at all, even though we could just ask for an extension, right? So instead of saying, oh, well, we can't get it done in 30 days, so we should just not do anything, is like, really? That's what world you guys live in. But what I would like to know from you guys is what you think is going to happen. Now, my prediction is that almost nothing will come out of Reed O'Connor's office. I think that he might grant them an extension of some kind to basically say, no, I'm not going to stay this. But I'll give you an extra 30 days or something like that to return it all, since you wasted the first 15, basically, probably by the time this whole thing gets responded to. And I'll, of course, cover the response, which I think will be great. This is still, of course, pending appeal, which is going to go to the Fifth Circuit. We've already seen what the Fifth Circuit thinks of this, and I expect that they are probably not going to issue a stay there either. They will accept the appeal, and they'll probably say, nope, looks like everything was good, probably, because that's just kind of what we have seen from this thus far. I don't have any reason to believe that this would not go that way. The only thing that I could possibly see, and this is why I've been a little bit cautious in telling people that they should just go out and get these things, is that we have seen vacatures reversed at the appellate level. We've seen that happen before, where a district court judge throws out the rule entirely, and the circuit court says, oh, well, that was a little heavy. And that's why you have, in my opinion, the bifurcation of the relief here. You have vacate the rule, throw it out, get it out of here, right? And then also he prescribed definitive relief for the named plaintiffs. So I think that the reason that was done was the concern about perhaps the rule getting thrown out, and that being the only thing that they said. If they had only said that, then they're kind of like sitting there with nothing, versus giving these two things to the Fifth Circuit, be like, hey, yeah, we threw this thing out and we also protected the plaintiffs. They could potentially say, yeah, the rule is still instated. They could discontinue the vacation, if you will, and still maintain protection for the plaintiffs. Of course, the easy response there is that if you purchased it from Rarebreed, then you would be protected as a downstream client anyway. Now, the knockoffs that are out there, not so much. I think that those ones would be, you would not be a downstream client of Rarebreed, and then the way to protect yourself there would be to be a member of National Association for Gun Rights. And I'm not trying tell you to go join another group or anything. But it seems like these protected classes of people that are popping up because of these injunctive reliefs. It wouldn't surprise me if this sort of thing, if it continues to happen this way, changes the way that courts issue relief to plaintiffs, because the whole concept is that we want to narrowly tailor the decision to the plaintiffs so that the defendants don't have a leg to stand on and come back and mess with our decisions from an appeal to a higher court. I get that concept, but when you're talking about criminal prosecution and things of the like, you're creating protected classes of people over regular citizens, and that's problematic in itself. But anyway, let me know what you guys think about this. What do you think is going to happen in the comment section down below?